Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing U.S. visa applications at U.S. embassies outside the United States. In recent days, or at least in recent days contemporaneous to this video, we have been hearing things about new changes to what's called the public charge rule. And there's a lot of stuff floating around about totality of circumstance tests, the I-944 form, etc. Means-tested benefits associated with being in the United States, but I haven't done a video yet on those topics, and I am doing them. I'm making them as we speak. I'm crafting them sort of behind the scenes, for lack of a better term. I guess I'm not making them as we speak specifically, but they are being made contemporaneous with this video. That being said, this video is specifically about a new form, the DS-5540. Now, the I-944 form generally pertains to those cases which are processing in the United States. So things like an adjustment of status in the U.S. or a change of status in the U.S. to immigrant status in the context, oftentimes, or at least for purposes of this channel, of U.S. family visa benefits. The purpose of this video, though, and the DS-5540 is this public charge rule has gone abroad, for lack of a better term. It's gone international. So the public charge rule applies in the United States in a slightly different context than it does abroad. But Department of State has received authorization to go ahead and implement the rules regarding the new public charge rule. And this DS-5540 form is sort of the manifestation of this new regulatory regime. So it's a public charge questionnaire. And just FYI, this stuff is coming at us relatively fast. We're in kind of a state of flux when it comes to these issues. So this public charge questionnaire, it asks a lot of stuff. It asks, do you have health coverage in the United States? Will you be covered by health insurance within 30 days of entry in the United States? Things like household size, assets, resources, and financial status, types of income, types of assets, types of liability. Have you ever been on public assistance before? So that's usually means-tested benefits, but things like SNAP, TANF, so that's Supplemental Nutrition Assistance Program, and the Temporary Assistance for Needy Families, Housing Choice Voucher Programs, and it allows you to list the types of benefits, etc. It has educational questions, graduated high school, occupational skills, various certification questions. So there's a great deal going on with respect to this, and I can't get exhaustive in this video. I just wanted to get this out as quickly as we could because this DS-5540 is going to start having a substantial impact on cases processing not only through the U.S. Embassy here in Bangkok, but also around the world, as this form is going to be starting to, I should say, it should start being used relatively quickly. It is also my understanding that the discretionary authority placed on the consular officers is going to change a little bit with respect to the issue of public charge. Now, we definitely know how this is going to work with respect to officers, I should say, immigration, USCIS officers in the United States. And the discretion basically is there's now an adjudicatory point of fact which needs to be undertaken by the immigration officer, wherein they have to look to see if there's any chance that they think you may prospectively be put on some of these means-tested benefits. Again, SNAP and TANF, Section 8 housing, etc. It's my understanding as of the time of this video, WIC and Medicare Part D are not part of the framework that they use when adjudicating this. But it's also my understanding consular officers are also going to be empowered with this same level of discretion. So they have to be, for lack of a better term, assured that you can or you are not at risk of going onto one of these benefit programs if you're admitted in the United States in immigrant spouse status. So things like the CR1 and the IR1 visa are going to be impacted by this. I think they're going to be impacted by this quite soon because these rules have just come down and they are now in effect. We sort of have had the metaphorical sword of Damocles over our head with respect to this for some time, and not to mix metaphors, but the other shoe has now dropped because the Supreme Court has upheld the validity of these regulatory changes. So we have to deal with a change to the public charge rules. And again, the manifestation of that out here in the consular processing world with respect to embassies and consulates abroad is the DS-5540. We'll make other videos on this channel regarding this topic specifically, and I will kind of, for lack of a better term, backtrack and get into the I-944 and some of the other things having to do with public charge rule changes. But for consular processing, which we do a lot of out here because we're based outside the United States, for consular processing, the DS-5540 is going to be where the rubber hits the road with respect to the public charge rules in a U.S. immigration context. We hope you find our videos insightful. If so, please like, subscribe, and hit the bell icon so that you can receive up-to-date notifications of legal news in Thailand and the United States.